Nani ninjani mulweni avsheni tobelanda. Guys, it's unjustified enrichment on Tuesday is going down. Tuesday is going down. It's going down, and many people will pass, many will fail. And then, thank you very much for watching this video, and I hope that it will be useful. And on Tuesday, I hope that it will. So, guys, the problem is that some people wanted classes, and I cannot give you classes because the time was already imminent for examination. Therefore, I will have to work very hard, which I don't want to, for various reasons, because I have helped many people from different modules. So, guys, without wasting any time, let's go and check this. So, last time on that video, we talked about the general requirement for the defendant enrichment that must have been expense of the plaintiff. And then we talk about the case of A, who sold uncut diamonds to B for an amount of 10,000 in contravention of the statute law. And I send documents to those people who have joined my YouTube so that they can get that document, because nothing for Mahara, it's a national anthem. If I can recap, I have answered this question for 15 marks, and then I came here and answered, and most of you I have sent you I've sent you this document, and I hope that you have it. And then we go and then we deal with a question number 2, which we're talking about A, who sold, and I send it to you this case, and I hope that all of you have this document, and then yeah, you have it, because I sent this document to everyone who followed me and who joined, right? I told you that you must join there with the 1900. Those that have joined have got this document. So we are going forward, guys. So this is the May-June 2024, right? Enrichment, liability, and estoppel. It was written for 3 hours, and those that have written for 3 hours, because it's a closed book, and then you have to be specific when you write. It was the last semester, this one. And then we go straight to the question of the day. Where's that question? These are the questions. These are the questions, and I was trying to make it so that maybe I may finish up answering this question. Okay, now let's deal with these questions. Number 1 says that write a critical discussion on how courts supplement the noun recognition of a general enrichment action in South Africa. This question always come with a 15 marks. Come with a 15 marks in the examination. And then you are likely to write about the general enrichment action, right? The noun recognition of a general enrichment action. Now, over here we have a study guide, as I've said, and then it means that the general noun recognition are discussed way down on the last one. Let me check here. Way down on the last. Yes, these are general enrichment actions. And then when you come here, you'll find more information when they are writing a lot of information. And you'll be like, oh, I'm reading, my gosh, I'm reading. However, you have me on your side. I've already summarized this well for you, so that when you get into the examination, it will be peanut butter, this question. So this is how I summarized. So in the examination, they can come with saying, write a critical discussion on the existence of a general enrichment action in South Africa. Or the way they ask on the previous question paper, said, write a critical discussion on how courts supplement the noun recognition of a general enrichment action in South Africa. Still one thing. Let's start. Before adoption of constitution, some authors thought that subsidiary general enrichment action will develop. Then we give case by Noji, because they were talking about cases. Remember how courts supplement. The court rejected the existence of a general enrichment action, but intimated that such an action may develop in future. In Commissary versus Benlanzie, in Komotse, William Williams' case, the appellate division confirmed its stance on the general enrichment action, but stated that the existing actions may be extended in future to cover circumstances where an enrichment action had previously not been available. In the current legal sense, a guideline has been put forward through the leading case, and then there is a case of Miss Casey, which is leading case, where there must be an impoverished plaintiff bringing their case forward and an enriched defendant that must defend such enrichment. In order for there to be an unjustified enrichment claim, there are two more factors that needs to be taken into consideration, which is firstly that the enrichment of the defendant is at the expense of the plaintiff, and secondly that there is no legal justification for the defendant's enrichment. The courts in South Africa have yet to make a pronouncement on whether a unified general enrichment action exists within the prescripts of the current law. As it currently stands, South African law does not recognize such an action because of the last 2 points of the guideline given in the mentioned case. This is because it's quite a daunting task that will reduce the whole case to be reduced to hearsay at the bare minimum. Moreover, there's a rule coined as the double cap rule. Double cap rule. At a close of pleading to determine whether there's unjustified enrichment, the plaintiff must be impoverished at the expense of the defendant, and if there's no legal justification, then the plaintiff is entitled to the excess amount that will place them on an equal footing with the defendant at the whole matter began, which makes it very difficult for the court to authoritatively recognize the general enrichment action, because not all enrichment claims are unjustified, even in the absence of a legal justification. If the double cap rule is to be applied, then the parties who are aggrieved will be left with no remedy. The courts had many opportunities to make a pronouncement on the recognition of a general enrichment action. However, the main argument that has been advanced is that it will be opening a floodgate of opportunistic and baseless claims that would have otherwise failed in delicate contracts. At this juncture, it is clear that unique case that will call upon the courts to revisit this conversation may not be forthcoming, and this creates a lot of uncertainty as to how a general enrichment action would look like. There is no need for a total overhaul of this particular area of the law, and a more aggressive approach should be taken rather than a piecemeal extension of the existing system that is going to be rendered obsolete through the progression of time. Then 15 marks. Wah. This document is available. Another thing before we move back to the question paper, there is this enrichment must has been sine, causa. When you get into the examination, there will be 15 marks question or 10 mark question asking about you to tell them about the enrichment that must have been sine, causa. This question may come on Tuesday, but because you have me who do the job, I've already do some summary of this one, and the summary goes like this. So as I've said to you, you will get a question that says that discussed by reference to the relevant case law, the requirement that the enrichment must have been sine, causa, and it mostly come with a 10 marks. So this is how you must write. If enrichment liability was solely reliant on one party gaining at the expense of another, it will be too wide-reaching and could potentially hinder commercial contracts, as nobody could benefit at another's expense. Hence, a restriction was necessary to limit liability to situations where it would be unfair and unjust for the party to keep the advantages gained at someone else's cost. The condition that the enrichment must be sine, causa functions as a restrictive element. Van de Voort explains that the enrichment is considered sine, causa when there is no pre-existing obligation between the enrichment party and the impoverished person that would allow the impoverished person to demand the transfer of assets. Divorce criticized this definition. He argues that following the definition as it stands, if a person receives benefits or gains ownership of a property without any obligation between parties, they will be considered unjustly benefiting at the expense of another. Divorce defined enrichment as unjustified when there is not enough legal justification for the transfer of or retention of value between parties' estate. Even though the Sine causa requirement does typically pose a major challenge, courts have struggled with it in a certain instance. Then I give by the case of Green Hill Producer versus Benjamin, where Van der Ryan J. understanding of the Sine causa requirements demonstrates a lack of understanding of the requirements nature. Whether enrichment is without a cause or not is not determined by subjective factors like errors made by the parties involved. It is determined by whether there was a legal basis to justify the enrichment objectively. In this situation, there was no basis for the as the contract became invalid when the company was provisionally wound up. It didn't matter if the parties were aware of this fact or not. The existence of the causa is a matter of factual inquiry and is independent of the parties' belief. And then I give another case of a Abi and Palestinians, where they said that the appellant division ruled that the owner only received what was agreed upon in the contract with the developer. So the owner enrichment in this situation was not without cause. Rather, it was the result of the contract with the developer. The subcontractor had the option to enforce their contractual rights against the developer, and if they found to be ineffective because the developer was insolvent, it would have been an unfortunate event, but it will not make the owner gains unfair. The owner will still be responsible for paying for the work done, even if they were insolvent, meaning they will not benefit from the situation. And then we gave a case, the last one, where it was held that even if enrichment has been caused by breach of contract, it will be regarded as Sine causa. Yes. And you get 10 marks. 10 marks, 10 marks for that, and the examination becomes a fish and chips. So before we go back to to the examination, I answered some questions that I put it because I just have a gut that it may come in the examination. So I put it, and then this is the question that I did for you because I want you to understand the remedy that is available here. A is the owner of the car manufacturing factory in Port Elizabeth. He recently settled his electrical bill in full with Nelson Mandela Metropolitan Municipality. However, to his surprise, he has just received a letter from the same municipality in which they threaten to cut his electricity if he doesn't immediately pay his error account of a 300,000. A knows that there must be a mistake because his account is paid in full, but also knows that if there is a disruption in his electricity supply, he will suffer severe losses. He pays the amount immediately and sends a letter of a complaint to the municipality, advise A whether he will be able to reclaim the 300,000 he paid, and if so, in terms of which remedy. In your answer, discuss the requirements for this remedy. So there's a 10 marks for that. In the examination, you may get this question. Let's start. Is there any misrepresentation here? No. This question has nothing to do with misrepresentation. Therefore, the estoppel study guide is not the one to be used. You can read here, there's no one who is B. but the municipality is saying that he's still owing, whereas he knows that he have already settled his bill. Therefore, in this one, it means that when he pays again, it means that now municipality is enriching itself with 300,000. Then this question is based on unjustified enrichment. Of course, it's based on unjustified enrichment, and this one we know what it's based on. Of course, we just say that one, and we come and write conditio. By the way, you must always be vigilant about conditio, because many questions there will be one question about conditio indebiti. It's a remedy, conditio indebiti. There is no way that you can write a question, an examination which doesn't have a conditio indebiti. So this one, conditio indebiti, is a very good remedy when you have, or when you pay something by mistake, when there's a mistake, or when you pay again when the amount is not due. We use the remedy of what? Conditio indebiti. Conditio indebiti. This one. Conditio indebiti. You must never forget this one. When you get into the examination, there will be many questions from conditio indebiti. Right? I have already summarized it for you. As you know me, you can come and read about conditio indebiti. However, I've already done that for you. You can see this question, municipality. I've answered it for you, and I said the A has the conditio indebiti as a remedy. As I have said, A must prove that this option is applicable when a payment is made for a debt that is not owed. No illegally beyond one authority or invalid contract is applicable here, and it appears that no other condition could apply. The requirements that A should have exchange of ownership by either monetary payment or handing over a particular item. Payment must be made with the false belief that the performance was required. The error, whether legal or factual, must have been understandable given in the situation is towards error. Typically, a party cannot recover performance using conditio indebiti if they knew the performance was not owed. This behavior will be seen as a gift unless it was done under duress or objection. In the case of CIR, which I've given, the FNB paid stamp duties to the Commissioner for Inland Revenue that was not actually owed, but did with with objection. The lower court ruled that the reimbursement of the payment could be sought under the doctrine of unjustified enrichment. The majority in the appellate division concluded that the money could be retrieved through a silent agreement, while the minority argued that if payment is made in this situation, the assumptions of a gift is no longer valid. A reluctant made a payment while being threatened and expressing disagreement, aware that the debt was not yet due. The conditions for this conditio indebiti have been met. So when we conclude, we'll say, in order for A to win the conditio indebiti case against the Nelson Mandela municipality in this situation, he needed to demonstrate that he did not owe the municipality the 300,000. Additionally, the payment was made under duress with the threat of electricity supply suspension if payment was not received. Thirdly, objected to the payment amount at the time of payment by sending a letter of complaint. Sorry, when I write, I always say, I write my name. My name is Temi, by the way. So I always write my name when I'm answering the question, so that I come back and put A. Because you know the questions are always A or B. So I always put my name so that I don't forget when I'm writing that this is for A. And then I'll say that A will be able to meet all three requirements for this exception and will prevail in the enrichment action against Nelson Mandela Metropolitan Municipality. Boom! You got the 10 marks. You see how easy I'm answering? I don't want to explain much because, of course, there's no time for explanation. You are going to write on Tuesday. Sorry for the mic falling away. I know you heard some. Sorry for that. Okay, let's continue. Another question that you will get into the examination, it will be like discuss in general without reference to a specific enrichment action how the extent of enrichment liability will be calculated. Yeah, will be calculated. This question may come this Tuesday. This question may be there, and you have to answer. But I've already answered for you this question. The extent of enrichment is established when the action is initiated. Every case must meet these overall requirements in addition to the specific requirements of each individual action. This indicates that if the defendant's enrichment is gone before the lawsuit is filed, the amount they owed is lowered. This indicates that the defendant is not responsible for any advantages gained from enrichment. The responsibility to demonstrate innocence lies with the defendant, who must prove lack of gain. Enrichment is determined when filing a claim, while enrichment liability is calculated in advance. In our legal system, 4 situations are acknowledged when determining enrichment. Enrichment can be determined once the defendant is conscious of it. It can be calculated from an early point if the defendants acknowledge the unjustified gain or act in bad faith. Finally, when the debtor falls into default, the questions mentioned above are not relevant for individuals who are underage due to the fact that minor responsibility is limited when the lawsuit is contested. The goal is to prevent gaining an advantage and failure at the cost of someone else. There must be a causal relationship between enriched and impoverished. Enrichment is considered to occur in the absence of a legal basis for fulfillment. If the defendant can prove that the unjustified enrichment was not their fault, their liabilities reduce once they become aware of it happening to another party. When the defendant is found to be negligent, they must take responsibility to the full amount from the moment they are made aware. Although defendants acknowledge the potential for justified enrichment, their liability will only decrease if they can demonstrate that it will not their default. So guys, I'm finishing there and you get a mark. So I've already compiled this one questions for you, so that when you get into the examination, there will be something to write. As you can see, it will be likely fun. All right. And lastly, guys, I'm very, very proud that you have watched this unjustified enrichment, or it's because many of you, it's a must. Eh? You are in a must watch because the examination is around the corner. So, guys, don't forget that when you join here, when you press a join, when you press join like this, you will just come and see 99 rand. It's very much important to support another guy, So after joining, I said that after joining, you request the documents, right? If you have already joined, then you request the documents. But don't come to me on my WhatsApp and said, Munyai, give us document. I'm telling you, when you have not joined, you are not even joining, but you want everything for free. No, guys, this is university, you must know. So after joining, guys, you will get that document so that if there's a question in the examination, you will have a very expensive reference. And I'm still going to compile another document so that to the examination, it will be, fat documents waiting for you to pass. So thank you very much, guys, for watching. Don't forget joining Aina Bungosi.